I appreciate the opportunity to be here. I always enjoy advocacy conferences where we can talk about where I live, which is collective bargaining for NSCA members and locals, and that's what I do. The program shows that this is supposed to be about the rules of engagement. Well, we're going to talk about the change to those rules, because there will be change. I want to start off with talking about, doing my history class part, talking about how did we get here and why, and then we'll move into the change or changes that are on the horizon, and Jerry will be talking about those legislative challenges that are pending literally as we speak. And we were going to talk about how we're organizationally, you included, are going to respond to the challenges that are out there. Now to the history part. I'll try and make it short, and there will be no test. Actually, the process we have in Nebraska began in 1920. There was a constitutional convention at that time to rewrite a new constitution for the state. There were some other things going on in 1920. It was obviously post-World War I. Also, there was a move to establish public power, public electrical power in the state of Nebraska. And there was nationally a movement towards unionism to establish the development of unions. The founding fathers, if you could call them that, in 1920 wanted very much to protect the public power, development, and industry, and so forth. And they didn't want stoppages of public power, regardless of what the issue was. They didn't want stoppages, which of course was, if you have unions, you're going to have strikes. So they adopted Article 15, Section 9 of the Nebraska Constitution, which provides that laws may be enacted providing for the investigation, submission, and determination of controversies between employers and employees in any business or vocation affected with a public interest. And they further provided an industrial commission may be granted for the purpose of administering such laws, and appeals should be as provided by law. The Industrial Relations Act, which is the parent of the CIR, if you will, is one of those code laws that the Constitution referred to. Now, that language was adopted in 1920. It sat there basically untouched for the next 27 years. In 1947, that act I just referred to, the Industrial Relations Act, was adopted. And the legislature then provided in 1947 that the following: the continuous, uninterrupted, and proper functioning and operation of government service is hereby declared to be essential to the public's welfare, health, and safety. That same act went on to provide that the public policy of the state is set forth in the prior section. There is hereby created an industrial commission to be known as the Commission of Industrial Relations. Consistent with that mandate, then, the Commission of Industrial Relations was established. And it provides, as it does today, the CIR shall establish rates of pay and conditions of employment which are comparable to the prevalent wage rates paid and conditions of employment maintained for the same or similar work of workers exhibiting like or similar skills under the same or similar working conditions. That's the base, if you will, cornerstone, whatever phrase you want to use, of our system. Be it K-12, be it community college, be it state college, be it ESUs, they all ultimately rest on the Section 48-818 foundation, which I just read, and that's the comparability. And it's a comparability standard those words are important. We'll get back to them, but remember them. But it's comparability that lies at the heart of it, and that's how determinations are made. And comparability, for those of you that have done comp studies or know what those look like, they are objective sorts of analysis. And that too becomes significant when we're looking then at the state bargaining act, and Jerry reviewed some of the legislation that's pending. The role of the CIR was to provide a remedy because striking wasn't permitted. Part of that whole legislative package, going back to public power, no interruption, no unionism, was all premised upon the idea that there needed to be a dispute resolution mechanism, something to level the playing field as between management and labor. One of the goals of any labor law, regardless of jurisdiction or what it's called, is the balancing of power in the labor market. And that's the CIR, and I've explained this to the legislature, and we'll do so again and again and again. They have some, and I can't say that. People warned me. Needless to say, it's important to realize that the CIR really provides a Band-Aid for 1 year. When parties are in a dispute in a labor sense, it affects 1 year. It's just the way it works. And that's what the requirements of the CIR is, that you establish terms and conditions for a year in question. If there's no agreement, the CIR applies the Band-Aid, establishes terms and conditions of employment that are in effect for 1 year. And the CIR, if you look at their decisions and so on and so forth, usually they have sort of an underlying tone, if you think about it, something like a divorce. If both sides come out of the court or the Commission of Industrial Relations not very happy, then the CIR has probably worked right. That it's probably achieved something that's fair and reasonable, and no one really likes it too well. We try and exceed from that standard and search for obviously very good outcomes is our goal. And when we talk about continuity of employment and so forth, with all the CIR bills out there, I trust none of them are labeled the demise of Mark McGuire law. They do away with the whole thing. The same arguments were submitted last Monday before the Business and Labor Committee in terms of establishing a level playing field and how that's significant. The uninterrupted provision of service is important, and that's why we oppose all of their bills. And that is, and now it's going to be Jerry's turn to talk a little more specifically, but the system that we've created, because it's well known, and we've done it frequently, for a long time, it has established a very high level of predictability. Any of you, as you're aware, you do a comp study, not that you're necessarily going to bargain towards comparability, but rather you have that information available, knowing that what it is the CIR would likely do if they had your case. It provides obviously very excellent information. The cities, the municipalities, the police and fire and so forth don't enjoy that level of predictability. In my view, that's the result of each side has tried to establish something that's a benefit to them that's not necessarily a benefit to the whole. Sometimes we're criticized that our system is kind of stuck in the mud. It only gets up to midpoint comparability. all things considered, against the backdrop of the 5 or 6 bills that we'll be talking about, it's wonderful because it does get to accountability, it does get to a medium, there is a dispute resolution mechanism that works, there is predictability. We don't wind up anymore having all that many cases because most of them settled, because most all negotiators now are quite adept at comp studies and know where they're at when they're bargaining. So we've told the legislature our system works, it works for us. We want it left alone. Whatever you come up with that addresses needs and concerns of municipalities or firefighters or police or whomever, fine, you know. Now, I think it's safe to say the CIR will continue to exist after this legislature. The exact form it will be in is less than clear, and we can add some specific kinds of stuff here as we discuss some of the bills, but that's the process. Obviously, in the last year or so, of significance to certainly the state, well, significant to all our people. Both the SCADA cases and the State Board of College Trustees cases in the Supreme Court affirmed the decisions rendered by the CIR. Those cases are under what's known as the State Employees Collective Bargaining Act, but the ultimate criteria of that act, we get back to 48.818 comparability. Same or similar workers doing like or similar things under the same or similar working conditions. That underlies everything I said a few moments ago. It underlies and provides the foundation for the State Employees Collective Bargaining Act. So these two cases that were State Employees Collective Bargaining Act, since we got a couple minutes, I'll get into this. And this won't be slander, so you can have it in there. It'll be accurate because what I'm going to say is the state is a lousy loser. And I say that because the true origin of the State Employees Collective Bargaining Act, which was the subject matter of these cases that were decided this year, were a series of 5 cases that were joined together that we brought in 1987 that sought to establish CIR jurisdiction over various state agencies that employed teachers, like Department of Corrections, Department of Health and Human Services. They provided the teachers at places like Whitehall and Lincoln, or the Youth Development Center in Kearney, that group. And the state took the position the CIR can't tell us how much we're supposed to pay those teachers. Well, the Supreme Court thought otherwise, and they said, no, the CIR, yes, CIR can do that. That then led to the State Employees Collective Bargaining Act, which was the subject of numerous meetings with several different senators. The state hired an expert from Iowa to write what was supposed to be in the law and so forth. We never liked it a lot, but went along with it, and it has worked. There are a number of cases that got resolved. It's the law that provides for the special master that you might have heard about, but it's a separate bargaining act than for state employees, and it was fully upheld. The true essence of the Supreme Court decision was the adoption and validation of what the CIR and the special master had done, how they had followed the process outlined in the law, came up with an outcome that was favorable to us, an outcome that was favorable to the board or the CIR. So now they've lost again. So this year, then, they introduced legislation again to seek to change the rules. And my cynical side says it's kind of funny in a way, because they're the folks in 1987 stuck in the special master concept that was supposed to be, really good. And now their lead bill, LD 555, deletes the special master. So, you know, go figure. But that was an outcome for this summer that was very nice to achieve.